evening, everyone. My name is Baruch Greenwald, and on behalf of our firm, Greenwald Weiss, and my partner, Hillel Weiss, I'd like to welcome everybody, and we appreciate you joining us here tonight. Our firm was recently launched, and we're a law firm focused on estate planning issues, and we are based out of New Jersey and New York, and really one of our primary goals is really to create an awareness and for all individuals about the importance of estate planning, and this event was planned with that in mind. So with that said, really our goal is, there are a lot of speakers on the schedule for tonight, and our goal is really for every speaker to speak in somewhat of a condensed fashion, and for everyone here to at least walk out with something, a piece of information, additional knowledge that they were unaware of prior to coming here this evening. Generally, in our world, in the firm world, this time of year is one marked by contemplation and introspection. Both obviously are important elements and prerequisites to planning, which is obviously essential. Today, being 9/11, I'm sure everyone was aware of that. I thought it was also a day where it wasn't planned, to be specifically on 9/11, but that was a day, and it still is a day, that sort of triggers in one the emotions about how things can suddenly drastically change in seemingly a minute. And therefore, the idea of planning and really thinking about things in advance is for everybody, and something that all people should really think about. I just want to, again, just finish off my introductory remarks by thanking the Lakewood Courtyard for hosting the event, and specifically Chana Dana for setting up the event and coordinating the event together with me. Also thank our other sponsors, the Marks Law Firm, PC, and its founder and principal, Bill Marks, and another sponsor, Medicaid Solutions, and Mindy Solsberg, and both Bill and Mindy will address us soon. So I want to thank our other presenters, and of course my partner Hillel for doing everything leading up to the event. We feel that this event will be a unique experience, and we hope that all of you enjoy and learn something that can make a difference in your life or in the life of a loved one. With that, I'd just like to introduce Michael Flam, the administrator of the Courtyard, to welcome everyone here tonight on behalf of the Courtyard.
Very much of your time. Nobody came here to speak. Don't get nervous. Usually speakers say, I'm not prepared to speak, and I'm just going to speak shortly, and it ends up being very long. It really will be short. It's a pleasure, it's an honor to welcome everybody here, and it's a pleasure and an honor to host this gathering for the simple reason I'm the administrator of the Lakewood Courtyard, so I deal on a daily basis with the elderly, and I cannot emphasize enough how important it is to do planning beforehand, if at all possible. All too often, what happens is people have what's called spend down, they run out of money, things weren't planned properly, and then what do we do next? Mrs. Mindy Salzberg has pretty much been with us from the inception, helping out. Almost cut her baby teeth on it, if you will. She was with long-term care, but then came over because assisted living is a whole different ball with wax. And she can tell you the hardship and how difficult it is sometimes to fix up something that happened after the fact. I will leave you with just one other point. This goes back to a previous life of mine when we did software development for AT&T. At those days, so this is over 30 years ago, it was $7 to fix a bug in software that we found before testing. It was 15 or 20 when we got it in testing, and it was like $700 once it came out to the field to do fixing of software. It's, in a certain way, it's similar here too. Whatever is possible, it's kedai to do beforehand. Like I said, I don't want to take up your time, but we're very happy to be able to host this and to present this, because this is something that's near and dear, and We live with it every day. Thank you.
Thank you, Methel. Our first featured speaker, mentioned before, is Bill Marks. He's a preeminent figure in the area of German reparations and pensions. He has been actively involved in this area for close to 20 years and has represented and assisted over 17,000 individuals and their families in their quest to receive their reparations. In recent months, there have been significant developments in the world of German reparations and pensions with the passing of new laws that have made many survivors and their heirs or descendants who weren't eligible in the past for such benefits. And it's also expanded the territory of areas that have become, where people have become eligible from different areas which were not eligible before. And Bill will discuss some of these relevant changes tonight. Risey Horowitz has joined us here tonight as well. She's the senior coordinator at Nachas HealthNet in Borough Park, and she's an expert in the field of German reparations. And she has worked together with Bill to assist thousands in their quest to receive what is rightfully theirs. So with that, I'd just like to call upon Bill, and Bill has a lot of information to share. He has a wellspring of knowledge, and he will definitely be very enlightening.
Great things about getting into this field was in 2001, I believe it was, I got a phone call from some woman from Borough Park named Risey Horowitz who had a question about German compensation, and she said, I've been asking this question, nobody knows the answer, and she called somebody up at the claims conference, and this gentleman who I happen to know said, okay, you gotta call this lawyer, Bill Marks, I bet you he's gonna know. And I think I probably knew the answer, and that was the beginning of a wonderful friendship and partnership. And I'm happy not only to see Risey, but Risey's husband, and I met a cousin, Methel. So it's really been a terrific evening, and it's barely gotten started. So Risey, by all means.
All right, half the speech, and I said we were going to fill out applications. There was nobody there. Nobody knew that they can get money. I walked into a grocery store, I stood up on a milk cart, and I said, if anyone knows a survivor, you're eligible for $10,000. You better get them here because we're leaving in a half hour if the room stays empty. Within 20 minutes, we had 100 people there. And I'm telling you again, there are new things that came out. There's something that came out this week that anyone born after 1928, January 1st, in January there'll be $2,500. If you're not listed as a survivor, you will not get it. If you were born in Austria and left in 38, you can get a $4,000 from the Germans. The Germans want to pay you. Take it. There is different things that are coming out every day. And I have, Baruch Hashem, I've had a lot of success because by me the word no does not exist. If I can't get it one way, I will find another door to open it up. But I've been successful, and then when I met Bill, all the doors opened up. So I just want to tell you, my card is here, anybody can call me at any time, but if you have family that has never received, don't think that you can't. If you have a spouse who never received, you can get on behalf of the spouse, which Bill will explain. But please, I'm begging all of you, the time is short, make sure that every single person who should get. They'll have extra money, they can put it under their mattress and enjoy it. Not you have to, or you can give to the Kinderlach. But let's not leave it in German hands when we have this opportunity. And especially the Polish Jews. They will be giving a $120 pension starting in about 2 months, and it's going to be for any Jew who was born in Poland, even if they went to Siberia. So there is things out there, it's not big money, $120, but for somebody who lives in unlimited money, this is something that they can use. So thank you, and I hope to hear from every single one of you. A good Shabbos.
The floor is mine again. Okay, I'm gonna just. Okay, I'm just gonna stand and talk for a few minutes because I only have a few minutes. I could talk about German reparations all day because there's a lot of information. That's a little audio-video issue. I want to thank Baruch and Hillel. I just met them recently for the first time. And we hope that this is the first of many joint appearances to talk about two things which really go hand in hand: Holocaust compensation and estate planning. Why is it relevant? Well, I'm going to go backwards and then from the back part of my presentation, which is very informal. I don't use notes. I've been doing this for 20 years. And here's a problem. If you're a Holocaust survivor, let me ask, how many people in this room are Holocaust survivors themselves?
I am a Holocaust.
Okay, I see 1, 2, 3, 4. Okay, very good.
What's supposed
Hold on, hang on. Let me speak for a few minutes, then we'll do questions, okay? I'm not leaving, you're not leaving. All right, so hang on. How many people here are the children of Holocaust survivors? Okay. How many, well, the issue for you and the people here is that money from Germany is, whatever you want to say, if there's money from Germany that's coming into someone on a monthly basis, or if there's money in the pipeline that could come in, that money is governed by whatever the planning is that somebody has done or not done. What does that mean? I'm going to put this, can you guys hear me? Yes, in the back? Thumbs up. All right, listen. If you're getting money from Germany and somebody passes away, a question is, for this audience, is what rights does the surviving spouse have? And more importantly, what rights do the children have? And I am here to say that 99.9% of my clients, and I have thousands of clients in the religious communities all over North America, but Flatbush and Williamsburg and Borough Park and Muncie and Monroe and Lakewood, and people don't have wills. The very basic document which governs how one's assets should be distributed. I'm not going to talk about planning, that's for my colleagues here to discuss. I'm merely talking about the existence or lack thereof of a will, because without a will, that German money gets divided pursuant to the laws of intestacy, meaning what happens when somebody dies without a will. And that can get complicated because maybe there's one child, then it's easy. Maybe there are 10 children, it's not so easy. And so you can't imagine, and oftentimes when we can't prove succession for the second generation, guess who wins? I don't win, you don't win, Germany wins. Because the money they won't release it. The thing about Germany, and maybe I will pick this back up. The thing about Germany, they paid a lot of money since 1952. In 1952, they established the Wiedergutmachung program. Those survivors who are here, maybe they get Wiedergutmachung, maybe the children of survivors know that their parents used to get it. That was the health pension, the Gesundheitsschaden. More recently, since 1997, Germany pays survivors pensions for having worked in ghettos. Now, it was originally designed for Polish survivors. Between 1997 and 2002, only Polish survivors. Between 2002 and 2009, more Polish and Lithuanian and other survivors, but the program was very restrictive. And after 2009 and into 2010, finally, because of work that my firm did with my partner in Berlin, Hungarian, Czechoslovakian survivors were able to collect. And the reason that the Germans didn't want to pay Hungarian survivors as opposed to, let's say, Polish survivors is a very simple reason. When the Germans went into Hungary in 1944, the ghettos that existed in places like Matoszolka or Munkacs, or every place really but Budapest or Debrecen, it was April, May 1944, 4 weeks, 6 weeks, 8 weeks, not long enough to qualify as a real ghetto. Unlike Warsaw, 1940 to 43, Krakow, 41 to 43, Lodz, 40 to 44. But now, in 2014, all survivors from various ghettos are eligible to make an application, but it's not automatic. Nothing, ladies and gentlemen, nothing that Germany does is ever automatic. Now, Risey pointed out one program which was just announced. That's going to be as close to automatic. If you're born January 21st, 1928 or later, you will be eligible. for a one-time payment of 2,500 euros. That's pretty straightforward. That's as straightforward as Germany will ever get. But he put that aside. And why I'm here is, again, I met Hillel and Baruch and Rizy, and I have clients down here in Lakewood, and I just want to say 3 points, and then I'll turn it back over to Baruch. And that is that if you are a survivor who is alive today, and if you have not yet applied for a pension for the ghetto, you need to do so, because the right to apply, the right for a second generation to get any monies, the right of a surviving spouse, you have to do it during your lifetime. Number one, and let's say that you are a widow or widower of somebody who might have died 30 years ago. You can make an application today on behalf of that deceased spouse who may have been in the ghetto. Why? Just because that's how we've been able to work the system in Germany. So a widow of, let's say, somebody that maybe got Vida Gutmacher and died in 1975, you say, how can I get a pension for that person? You can, trust me, but you have to prove it. And they won't take any, Germany takes nobody's word. You have to go and prove that the person was in this place and did this kind of work. And that's what I do. And that's what I've done for a long time. So if you are a survivor or you're a child of a survivor and the survivor's alive today and they haven't applied for the ghetto pension, you need to do so. Because that right dies with the passing of the survivor. However, if there's a surviving spouse, that person can bring a claim on behalf of somebody who passed away, but the children cannot bring any claim on behalf of a deceased parent if that person never filed during their lifetime. And I get questions all the time. I get calls from second generation all the time. What rights do I have? And my answer is you have nothing, zero. Germany considers you, as I say, the right to a pension is the right of the survivor. The right to a pension is the right of the surviving spouse. The child of a survivor can continue a claim that the parent brought during their lifetime, and if it's successful, you as the second generation can collect not an ongoing pension, but whatever the lump sum portion was of that recovery. Okay? So it's, again, I want to make it clear. And the way that the Germans, they play favorites. They play favorites, Polish over Hungarian. And now, if I know people here have family in Israel, the children of survivors who had Israeli citizenship have more rights, as do Canadian second generation, than American second generation. Why? Because that's the way the system is set up right now. So, hang on, man. Hang on. Just give me another 2 minutes, okay? Okay? You're the first person I'm going to call on is you. So, the thing is that, again, there's so much about reparations and compensation. This is what I've done for 20 years. And I don't know much, as these guys know, I don't know much about anything else. I know a lot about this. And I am immersed in this. And I do know to my core that the German government does its best to make it as hard as possible for people that suffered during the war to collect compensation. Because if it were easy, I wouldn't have had 20 years of a law practice helping survivors, because they wouldn't need my help. I wouldn't have worked with 17,000 people. I wouldn't have worked with Rising Orange for over 15 years. I wouldn't have spoken around the country and in Canada to survivor groups or second generation groups. And I'll leave you with this. Again, the current issue with ghetto pensions. Let me ask this. How many people here are familiar and know about and have worked with this ghetto pension program? Okay, a couple of people, 3 people. All right. So what's going on today with ghetto pensions? The Germans are doing something called a reassessment. It means that they're looking at the existing pension and they said, you know what? We didn't pay people as much as we should have the first time. We're going to go back in and we're going to backdate that pension to 1997. And by so doing, there's going to be an additional lump sum to pay. But again, of course, it's always more complicated, and it is more complicated than that. But that program is underway, and there's a consequence. An existing pension will be reduced, but there'll be a net lump sum, potentially, I've seen anywhere from 6,000 euros up to 46,000 euros. And it depends upon the particulars of the underlying pension. It is impossible, if you work with a social worker, if you work with a macher, and you all know what machers are, I don't need to tell you. If you work with people that don't have the ability to look over the shoulder of the German government, I will say this: Germany cheats. You know why? Because they can get away with it. It's unbelievable to me, and I don't have time. I could, but I won't. I have ample stories about how there's a pot of money on the table, and before they mail that money out, they take some and they put it in their pocket. So instead of paying somebody 10,000 euros, they pay him 6,000 euros. And you never know it. If you have somebody you're working with and you get a check and you say, oh my God, this is great, terrific. How do you know it's right? The answer is you don't. Because it's impossible. That's the thing about these ghetto pensions. Everybody's pension is different. You might get a ghetto pension of 250 euros. You might get a 350. Somebody else might get 75. Why? You know what I say, ladies and gentlemen? Every pension is like my thumbprint. My thumbprint is different than anybody else's thumbprint in the world. Every ghetto pension is different than anybody else's ghetto pension. Siblings, cousins, twins, all different, because there are always these little nuances. So again, I have forms here for two types of people. If a survivor, and I can leave them, or Risey can distribute them later, this questionnaire is for survivors who are alive or who have a spouse who is alive, to see whether it's possible to make a claim. And the second form is for heirs. It's important that heirs who may want to make a claim on behalf of the deceased parent, we have to be able to find a claim that was previously filed. If you know it was filed, that's great. If you don't know if it was filed, but you think it might be, we have to try to find it, research it. It's doable, but it takes some time. But I'll end where I started. German money, German compensation is part of, as you'll hear from my colleagues here, a broader assessment of your assets and how you can protect them. And from my perspective, only because I have to deal with this every day, when money comes in from Germany and there's no will and the children are trying to figure it out, sometimes it's easy, but more often than not, it's difficult. And I'm telling you, the lack of planning that I see in this community, for whatever the reasons, I'm not making judgments, I'm just saying there isn't much, is one of the reasons why I've said to Risey and I said to these guys, it's so important to work together, because what I do and what they do, I think, makes a nice match. So thanks for listening. I'll answer questions now.
So, the program is moving along, and all the other presenters to have their time before there's all that much distraction. We'll let all the presenters present, and then we'll have a short time before we all leave, where everyone can sort of ask questions to whoever they would like, and I'll moderate that from here. I saw that Bill really got everyone into things when he started asking the questions about how many of you. So, how many of you are having a good time? I figured I'll, at least get people involved. I spoke for a minute about our firm, and we pride ourselves upon providing service to our client, but most of all, what's unique, obviously it's about providing correct guidance, but what's unique is that we really are collaborate on everything we do. That's Hilla and I, and now we have an associate as well, and that's really our motto, is that we collaborate in order to really give clients their best possible results. As we know, Toiv Hashnayim and Echad, it's always, two heads are better than one. And with that, our presentation actually is going to follow suit. We're going to do something a little bit different here. the screen here is actually only here for our presentation, but Hillel and I are actually going to do a collaborative presentation, which hopefully will be interesting. Hopefully will keep everyone into things and won't be too distracted. Just to give everyone an idea of what's going to be happening, Hillel will be the attorney, I will be the client, he'll be Mr. Attorney, I'll be Mr. Client, and we're going to run through a little bit of sort of a client lawyer attorney interview, where we'll have facts surrounding what we feel is very relevant, especially here in Lakewood, where many individuals either came from New York or have interests in New York, and we feel that we focus obviously our practice on New York and New Jersey, and there are issues that do come up specifically where someone has assets or items in New York and New Jersey. So with that, we will get started.
So, Mr. Client, I understand you wanted to see me about doing some estate planning?
Yes, Mr. Attorney. I've been told that it's really important, but I don't really understand why it's so necessary. I don't really have that much in terms of assets. I have one home, I have investment property, I have a small business. But really, my children said it's about time that you see a lawyer and receive proper advice. But I really don't think it's all that important.
What do you think an estate looks
See,
like?
that's what I always imagined an estate to look like, a palatial estate. Not my small residence and my small family. That's really what I always understood an estate to be.
Okay, that's a common misconception that people have, and maybe at the end of this meeting you'll have a different perspective. So, let's get some more information about you. Tell me about yourself a little bit.
Okay. Recently, just a few months ago, I've always lived in New York, in Brooklyn, New York. I was married. Unfortunately, my wife passed away about 5 years ago. I'm semi-retired right now, thank God. Taking a little time off. My partner and I were both sort of sharing the burden. I have 4 children. 2 boys, two girls, all 4 are married. And right now, actually, I'm contemplating actually moving from New York to New Jersey and getting remarried and moving to New Jersey.
That's really nice. Sounds like you have a great relationship with your family. So, tell me a little bit about your investments and other assets.
Yeah, as I mentioned, we purchased our house in Brooklyn, where I've lived my whole life. We purchased that in 1972. Right now, the value is $1.1 million, give or take a few dollars. And we have no mortgage on the house, and the house has really appreciated in value since we bought the house way back when.
I also have a business, as I mentioned, with a partner. It's a small business, but it's been successful over the years. It's probably worth about $3 million total. We sold it today.
I also have some retirement savings, an IRA held in a couple of different accounts with the value of approximately right now around $550,000.
I also have 2 life insurance policies with a nice death benefit, and one has also a cash value of about $250,000.
Okay. It's $1.5 million. IRA, $550,000. Business interest.
I left out one thing, actually. I have also an investment property here in Lakewood. That's actually the property that I'm thinking about moving to. Though after being in the courtyard tonight, maybe I'll just move in here.
Okay, just keep it as an investment property. That's fine. Okay, and you have again summary. You have a business interest of about $1.5 million and death benefits of your life insurance policies. Back to of about $3.5 million, a total approximate estate of about $7 million. So this is a larger than average estate. But most of the discussion will focus on today, thank you, will be relevant to much smaller states as well. So
That's great, because I know I do have a lot of friends who are not as well off, and they've also said they have to do some planning, so
You're their advisor.
I'll relay that to them, yes.
Okay, so maybe tell me about what your concerns are.
I mean, one of my main concerns really is aging and aging with dignity, and ultimately there's a lot of issues that come up with terms of expenses, medical expenses, and I'm really concerned about depleting my hard-earned assets and my hard money that I've earned over my life. I wanted to leave that to my family, and I really don't want that to be depleted by long-term care needs if that should be necessary.
Okay, that's a very valid concern. And let me bring to your attention some other points which you should think about. You know, about managing your house, how your assets will be
I
managed.
never thought this was important, so I've done nothing.
Okay, so you have no power of attorney, you have no healthcare proxy, so no way that your assets will be managed in case you're incapacitated or you don't have.
I have nothing in place. I've done no planning at all.
Okay, what about, do you have a plan on how you're going to pay for your long-term care costs?
Didn't deal with that.
Okay. Now let me explain to you. Do you understand that currently approximately 60 to 70% of individuals reaching age 65 will need some form of long-term care in their lifetime?
Yeah, I've heard that, but I'm right now I have Medicare, and I figured that would be helpful to me and really cover whatever I need.
Yeah, that's true. It does cover something, but it's very limited. For instance, Medicare coverage of nursing home is very limited. It's only after a qualified hospital stay will cover you for 20 days, and then for another total of 100 days, it will cover you partially. But you need to think about what the nursing home costs are. For instance, New York, New Jersey nursing home cost is about $100,000 to $120,000 a year. In New York, it's about $135,000 a year.
Wow, that's a lot of money to deal with.
Home care costs are about $20 an hour for a nurse or an aide that you want to bring into your home to help you out. Let's explore some other options that you have that might help pay for your long-term care. There's long-term care insurance. The issues with that is that there's a limited number of companies that are still in business. You have to be medically eligible, you have to be healthy enough, and it can be very expensive. We'll have someone come in shortly and discuss that in greater depth. Another way to pay for long-term care is Medicaid, another government program. But your assets and your income have to be under a certain limit. In order to do that, you have to transfer assets out of your own name.
Well, that's interesting because I actually have many friends who just told me that at home, just to my children, as soon as possible, give it to them directly.
Well, from a Medicaid perspective, that might work. But from an income tax perspective, that would be a disastrous decision, actually, on your part.
You bought this property for $54,000, right? This is called your basis in the property.
Now, let's say you transfer your home to your children, and shortly after your death, they would sell the property. Or let's say it's worth what it's worth now, $1.1 million. So their gain for tax purposes would be over $1 million. They would be taxed about 30% on that gain. So about $300,000 check would have to be written to the government for tax purposes, and which could have been completely avoided if done properly. If instead of transferred directly to your children, we transferred to a trust for them, if you decide to do Medicaid planning. Even after you, one of the issues of Medicaid planning is making yourself quote unquote poor, getting assets out of your own name, giving up the control over them and giving up the benefits of your assets. And even after you do that, there's the other issue of if you should need long-term care, if you should need nursing home care within 5 years of that transfer, Medicaid will impose a penalty on you based on the amount that you transfer. And we'll have someone come later and discuss in greater detail the Medicaid eligibility requirements and application details.
So talk to me about all these, and so ethically this concerns me. Is it really ethically appropriate for me to start transferring my assets now while I'm living and then become eligible for government programs, even though in reality I had all these assets just a few days earlier?
Listen, there is considerable debate about the ethics of that, and it's something that you would have to become comfortable doing on your own. before you do such a thing. But
I will just quote you a statement made by New York's highest court, the Court of Appeals, in a 2000 case, which is very relevant to this issue.
they said, no agency of the government has any right to complain about the fact that middle-class people, confronted with desperate circumstances, choose voluntarily to inflict poverty upon themselves, when it is the government itself which has established the rule that poverty is a prerequisite to the receipt of assistance in the defraying of the costs of ruinously expensive but absolutely necessary, essential medical treatment. So that was just a court view on the ethics of that.
It's interesting. I just want to mention I have some other concerns other than obviously long-term care. Like I said, thank God, Baruch Hashem, we have a family, that one side passed away, that I really want everything to be distributed to them in a fair way, and that the harmonious relationships that our family share right now should continue. And I know, obviously, in addition to secular law, there's also a lot of halachic implications that can come up, and can ultimately, there's been a lot of stories I've heard where a once peaceful family really things turn in a completely different direction after the second spouse passes away and leaves significant assets.
As well as, for the frum client like yourself, have documents that can be held up in Bezin as well. Where you have the added risk, like for frum clients of dispute in Bezin. And we'll have someone coming by shortly to discuss the halachic ramifications of estate planning. Okay, so let me just bring to your attention another couple of points that you should be thinking about. You're contemplating remarrying. Have you taken the steps that you need to take prior to remarrying to make sure that your assets, that your children are protected, that your children will get the bulk of your estate and not your second wife's family? Another thing, you have a 50% interest in a business that has considerable value, $1.5 million. How will your children access this value?
That's fairly simple. My partner and I, we've gotten along for all the years. We've never had any agreement, but children will either be bought out by my partner, or they'll come in and it will be a seamless process. They'll join the business and everything will just continue the way it was.
And even if your partner is a great guy, he wants to do what's right, does the company, does the business have the liquidity to make such a payment? Even in installments? You think they'll be able to do such a thing? And you're talking about your children joining the business. Do you think your partner is fine with that, to have inexperienced people just showing up and joining the business?
They used to come in when they were kids. They used to come in and, so I figured they know something.
Another thing that you should think about, if you don't do any planning, the state does it for you. The state decides where your assets should go. Those are called the intestacy statutes of the state. In New York, for example, the intestacy laws are that half of your estate goes to the surviving spouse, and half goes to go to children. For many people, that's not what they intend. At least in a one-marriage situation, a typical situation. In Jersey, it is more typical. It's more what most people want. That all goes to the surviving spouse in a one-marriage situation. Okay. Do you have any other concerns? Like maybe something relating to taxes?
Yeah, my last concern, obviously, the taxes are passing to my family and not to the government is something I'm concerned about. And I've been told there are strategies that one can implement to make that happen.
Did you know that Pastor Shalom Yeshadai combined federal and state tax of about $1.5 million, and a big portion of which could have been easily avoided. And even people with smaller estates that are not subject to federal estate tax because of the higher exemption from federal estate tax, but they could still be subject to the state estate tax. In New Jersey, especially New Jersey, which has a state estate tax exemption of only $675,000.
But just one home can really go over that amount.
That's right. That's right. And another thing you should think about, you have real estate in 2 states. You know that your children, if you don't do proper planning, your children will have to go through probate in 2 states, New York and New Jersey, which could be a tremendous hassle of cost and time. Okay, I hope I enlightened you a little today about some of the aspects of estate planning.
You definitely did, and thank you very much. I appreciate it. Back to my regular job, not acting. I've always wanted to have an acting career. Our next speaker, we touched on really during our presentation, giving everyone a glimpse of what the next speakers will be talking about. Our next speaker, David Grossman, Dean of Beisvat Halacha Center. He'll be talking about the many halachic aspects that come up. Obviously, in every area of our life, halachic aspects do come up, but estate planning is nothing different. And he will talk about planning, gifting, and bequeathing, and give a halachic perspective.
Thank you very much for the presentation. There was a few points touched upon. The issues of families that don't do the proper planning, proper wills was mentioned before. It is important to note that any action basically that's done by the legal team, by the legal field, should be mirrored in a halachic, through a halachic document. There are many differences between the estate laws of New York and New Jersey and other places, and the way the Torah sets up the laws of Yerusha. And we're going to discuss today just basically 3 points, but obviously the halachas are vast and there's many intricate aspects of setting up an estate plan, and it is important that while working with professionals in the estate, in the legal and estate planning field, to make sure that everything that's done in those fields are done in accordance with halacha as well, and that the proper documents are executed. I'll start with an anecdote. When I was learning in Eretz Yisrael, I was talking to Zalman Nechemi Goldberg, who's the son-in-law of Shlomo Zalman Auerbach, and I was reviewing a contract of a piece of real estate. And somebody was buying and selling a piece of real estate, and he turned to me and he asked, "How do you know that this piece of real estate is not stolen?" So it was an interesting question. I wasn't sure what he was referring to, where he was going with it. Maybe stolen from the Arabs. It was an Eretz Yisrael, or I wasn't sure what he was saying. So he explained himself by saying that whenever a person passes away, their estate usually would go to the children. In Israeli law, the daughters and the sons divided equally. The wife would take half of the estate, half of the property. And what he explained is that since many or most of the real estate in Eretz Yisrael has passed through people who were not Shomer Torah mitzvahs, but they were Jews, what would happen is they would go to court, and in court they would divide. Let's say there was a son and a daughter. They would divide that piece of property equally. Now in the Torah, the way it's set up is that the son would inherit and not the daughter, unless a halachic tool is put in place, which we'll get to. But being the case that basically when a daughter would go to court and take what's legally hers, she would be actually, says Zalman Nechemi Goldberg explained, she would be stealing half of the apartment from the sibling, not knowing, because not knowing the laws of Yerusha, the halachas, and throughout the generations, many or most of Israeli real estate is actually in the wrong hands, which is something very significant, very serious. So When a person dies intestate without setting up a proper will or a proper tzavor, the way it's structured in halacha is that the son's Yarshin, the son is the halachic heir, and the spouse doesn't necessarily inherit their spouse. Now, there are many points to consider. Many times, money is placed in a joint account, which could be an actual transfer. That could be placing the funds half in each spouse's name. A piece of real estate, a home, could be bought on both spouses' names, which would have halachic ramifications. But basically, all the earnings throughout the years would, in accordance with halacha, would go to the son unless something, if there are sons, unless something is put in place. There is the famous halacha of pishnayim, that the eldest son born to the father would get a double portion of the estate. And again, if it's not taken care of properly, the other sons or the other children, that if one goes to court and divides the estate as per probate, as per the New York or New Jersey laws, they would be actually taking that portion, the double portion that really is coming to the oldest son, and they would be dividing it equally, and that would be, as Rabbi Goldberg quoted, that would be actually stealing from the son. And I can't tell you how much strife and how much anguish families go through in the Yerusha process, and the more, whatever can be structured and dictated and documented, it's really vital for the peace and the harmony of the family to really take care of these things in the proper time. It's actually interesting that in last week's parsha, the Torah talks about the halacha of Bechor, and the Torah tells us that the firstborn has to get pishnayim, this double portion, and it actually instructs us by stating lo yuchal levaker es pnei ben ahuva al pnei ben hasnua Bechor, which means that it's actually prohibited for a father to give the estate act equal and not to give the double portion to the Bechor. And the Nesius HaMishpat actually says a chiddush according to the Ramban's view, and he actually says that for a person to set up an estate without implementing, if a person, let's say, has a Bechor, if a person sets up an estate without implementing the halachic tools which facilitate for a person to deviate from the Seder HaYerusha, a person could transgress, could be over the law of the Yisra of Lo Yuchal Levaker Al Pnei Ben Ahuva Bechor, by actually setting it up, by stating that I want to make it equal. That is a violation of a serious law of the Torah. So it's something to consider. And not only that, arguably one should not sign a legal will without setting it up halachically as well, because that could be a violation of Lo Yuchal Levaker if there was a Bechor. When there's no Bechor, so basically, as a general rule, as was mentioned earlier, that anything that's done ahead of time, there are various ways to set up an estate, and basically, which you can set it up in any way that the testator would want to set it up. It just has to be done properly. So what's important is, to first figure out exactly how a person wants to set it up. And there is one very important point, which is the halacha is that the Gemara states in Mesechus Baba Basra that al tihi me'avuri santa, a person should not be from those who circumvent the natural succession of Yerusha. Now the Poskim explain that as long as there is a certain significant part of one's estate that is left to flow in the natural flow. The word nachla is from nachal, a flowing stream, and that happens without writing a will. When a person passes away, automatically his assets get distributed and pass over to the next generation in accordance with the way the Torah sets it up, which was mentioned before, not necessarily a spouse, and wouldn't go to the daughters equally. So if a person would like to set their estate up that it should go to their spouse, or to set their estate up that it should go to their spouse, and then all their assets should then transfer after the spouse's death to their children equally. This is all not exactly how the Torah set it up, but it's the Gemara and the Poskim allow us to put tools in place that will make this happen, and a person will be able to set up their estate however they'd like. But there is a certain significant amount which a person should leave to allow the natural flow of the Yerusha, and which is that would go to the sons, and the number that's given in the Poskim could be up to $5,000 per child. In other words, a person's married, has a wife and 2 sons and 2 daughters. So in halacha, everything should really go to the 2 sons. And the first son would get pishnayim. He would get 3. The entire estate would get divided into 3 portions. The first son would get 2 portions, and the second son would get 1. And the daughters wouldn't get anything in halacha. If a person wants to avoid resentment and wants to set it up in a way that everybody gets equally, that can be done. But in this case, $15,000 should be put aside, upon death, the first son should get 10, the second son should get 5, and then a person could circumvent the Yerusha with the rest of his assets and give it and have his wife, and it should go to his wife. What's very important is sometimes people want to make sure that their children will eventually get the funds. Now the halacha is that a husband, if no will is written, a husband will inherit the wife's assets. So what sometimes might happen is that upon the death of the husband, if they were to write everything over to their wife, and that the wife would get remarried, you run the risk. There is a risk that if she doesn't put things properly in place and she gets remarried and passes away, that everything would go to the second husband, and the children would not remain with anything. So something should be put into place, making sure that doesn't happen. That to make sure that if a person wants his children to succeed him, that should be put in place. Another thing when it comes to estate planning.
I'd like to ask a question. Question and comment.
We're going to have a panel
questions right afterwards.
May I?
Yeah, we're going to have a panel afterwards. All the questions will be
Right after he finishes. Right after everyone finishes, we'll have a few questions.
We should have a chance also.
Right, you will.
equal timing, huh? So, I'll just end with this, which is when a person puts into place significant planning, especially if there's an estate which has funds that there is life insurance policies and various things. It's important to set it up where we have to just first one thing to take into consideration is that when it comes to charitable giving, there's an obligation to give meiser 10%, and that when a person, even if a person all his life earned and gave 10% to charity, to meiser, when the person passes away, everything goes to the next generation, or possibly to the spouse. In certain cases, it has to be analyzed, but that person would have to give charity 10% meiser on whatever they receive as the Yerusha, as their inheritance, even though it's been given in the life of the parent or the life of the spouse. So many times, it has to be set up properly, just like people set up life insurance policies to pay for taxes, so that one doesn't have to sell off buildings in order to pay taxes. There's enough cash there. So part of the planning could be to put in place that there should be cash to give charitable disbursements. There are charitable trusts that can be put into place. It's an interesting question, which if a person, it's possible for a person to set up the way they earn and the way they deposit and hold on to their earnings in a manner where the wife would not have to give charity again on the funds that the husband had already given charity through his life, but that has to again be thought out and be set up properly so that it's structured in a way where the couple is earning together and giving charity together, as opposed to the husband giving charity and then when he passes away, the wife would have to give charity again, would have to give the 10%, which is not a terrible thing, but it's something to take into consideration when planning. Obviously, there's many many questions, we'll take afterwards, or our card is in the back if you wanted to call up and
get nifter. And there are no survivors. So instead the money should remain in Germany, shouldn't be a law, the money should go to Israel.
the parents pass away and there are no survivors.
There are the Holocaust survivors which pass away and there are no children.
So actually,
So the money remains in Germany.
right.
So we should
Bill
create a
definitely has
law.
an opinion on that.
The money should go to Israel.
That's a very good point. Bill
Am I
definitely
right?
has an opinion on that, and he can either address it now,
It's up to you.
or we can just get to that in a minute. So what we're going to do is, it's a great question, and what we're going to do is we're going to let the rest of the panel here speak what they have to talk about, and then we'll allow Bill Grossman. I wanted to introduce our next speaker. The next speaker is Mindy Solsberg of Medicaid Solutions. She's been involved in the Medicaid process and has been a Medicaid consultant for 15 years. She helps people spend down assets and apply for Medicaid, and she'll be able to provide a lot of very helpful information to everyone here tonight.
Well, I want to thank Mr. Greenwald and Mr. Weiss for organizing this event and arranging it. I want to thank Mr. Flom and Hannah Dana for hosting the event. So thank you all. It's greatly appreciated, and I want to thank also the Lakewood Courtyard for always being my support and always standing beside me for the last many years. I'd like to start out, we're limited in time, so I'm going to try to keep this short. I'd like to start out with just clarifying two terms that many people tend to confuse: Medicare and Medicaid. Medicare is a federally funded entitlement program, which is for aged people who are over 65, people who are retirees, or people who are disabled. Medicare Part A covers hospital insurance. Medicare Part B is for medical insurance. And basically, those insurances are very limited coverage for skilled care. Medicare Part A covers for skilled nursing in a nursing home, covers for up to 100 days, there's a set of regulations that are set up by the feds. However, each state administers their own state's regulations under those federal guidelines. So if somebody's on Medicaid in one state, they would have to apply for Medicaid in another state if they would move to the other state. So if somebody lives in New York, is on New York Medicaid, moves to New Jersey, now needs coverage in New Jersey, they would have to start a whole new Medicaid application process. For those of you who are familiar, New York's Medicaid guidelines are much more lenient than New Jersey's Medicaid guidelines. So whereas somebody is eligible for Medicaid in New York does not necessarily mean that they're eligible for Medicaid in New Jersey. That same goes for Florida, Pennsylvania, many of the other states. New Jersey is definitely one of the stricter states. Medicaid provides health insurance to many different segments of people. The segment of people that we're going to discuss tonight are the aged, blind, and disabled. Aged meaning over 65, blind is self-explanatory, and disabled means that the person has to be considered disabled by the federal government. Either they qualify for SSI or Social Security disability, or if they haven't yet qualified for those programs under the federal government, they would have to apply to the state of New Jersey and qualify through their medical review team as being disabled, which basically, under their terms, means that the person is unable to work for at least 12 months. So we're going to focus on the ABD programs, the age, blind, and disabled programs. Now, in order to qualify for these programs, as I mentioned, you need to be at least 65 years of age, disabled. You also need to be a New Jersey resident, and you also need to be a U.S. citizen or a qualified alien, a legal resident in the United States for at least 5 years. I'm going to try to shift this over a little bit. I'm going to try to speed things up because I know it's been a long night for all of you. What I would like to mention is that there's two parts to the Medicaid process. There's clinical eligibility and financial eligibility. Clinical eligibility, basically for these kind of programs, which the programs that I'm going to discuss are poolable options, Medicaid only, and medically needy. These programs cover for home care, assisted living, nursing home, programs that are going to give home health aides to people, give the assistance to elderly people that they need generally. The clinical eligibility for these programs basically is that a person has to qualify for, has to need at least 2 to 3, need assistance, I'm sorry, with at least 2 to 3 activities of daily living. Dressing, bathing, ambulating, showering, things like that would qualify as activities of daily living. As long as a person needs assistance with at least 2 to 3 of those activities, they could qualify on the clinical side for these programs, for the Global Options and Nursing Home Medicaid programs. On the financial side, it's not so simple. On the financial side, basically, we have the income guidelines and we have the resource guidelines. The income guidelines, I'm going to just give you in a nutshell. Income guidelines, as long as somebody has a gross income of less than $2,163 a month, they could qualify for Global Options, which is a program that covers home care, assisted living, adult daycare centers, and many other programs in the community or at home for these individuals. As long as their income is below that 2163 level, their income qualifies. If they have over the 2163, they can't qualify for home care, they can't qualify for assisted living. They could qualify for a medically needy program, which basically covers nursing home care. Now, when we talk about resources, obviously that's the complicated part, okay? Resources is how much money a person has, how much money a person's allowed to have, and how do we get them there, okay? In order to qualify for a basic Global Options Medicaid program, a person's entitled to keep up to $2,000 in resources. Now, many of you are thinking $2,000, that's nothing. You're right, it is nothing. We have to be able to see the big picture and plan, basically, and understand that even though somebody may have assets now, if they need assistance, like a home health aide or assisted living, the money is going to fly because it goes very, very quickly towards their medical expenses, and before they know it, they're down to almost nothing, and they say, hey, wait 1 second, my money's almost gone, I'm not going to have the care that I need, and now what do? Now it's time to think about Medicaid. Now, what we want to make sure is that you didn't only think about Medicaid when you're down to nothing. You think about Medicaid when you're well enough in advance to plan properly and to be able to look at your full financial picture and to be able to do some sort of estate planning and to be able to do some sort of Medicaid planning so that you could qualify when the time comes without having problems and without having to spend your last dollar on your medical care and having nothing left either to give your children or to do things that you always wanted to do for yourselves. Basically, what I would like to bring across tonight is I'm not going to go through all the details of the resource assessment and how we can spend down and allowable income, allowable resources and exempt resources because time just doesn't allow for it. I could spend at least 2 hours talking about it. What I will try to bring across to you is the Medicaid application process is a very difficult process. And I'd like to, if all of you walk out of here tonight, just knowing that you need to really watch what you do to plan for Medicaid. That will be a very big accomplishment. Basically, what I'm trying to explain to you is that in order for someone to qualify for Medicaid in New Jersey, Medicaid has a 5-year look-back history. They look back at 5 years of your financial history, and they'd like to see what is it that you've done with your money. Have you gifted it away? Have you used it for your own benefit? What have you done with this money? So basically what they do is they take 5-year histories of all your bank accounts, anything that's been open or closed within the last 5 years. They look at properties, they look at trusts, they look at stocks, bonds, IRAs, CDs, annuities, you name it, they're gonna request it and they're gonna look at it. Now basically what they're looking for is they're looking for a few different things. They look at deposits, monies that were deposited into your accounts, and they want to see from these deposits, where is the money coming from? So they're going to request copies of all the deposits that have been going into your account. Now sometimes you'll see in your bank accounts, you transfer money from one account to the next, it shows up right there on the bank statement, there's not that many questions to ask. What they will need to ask is, if I see a transfer coming from account A to account B, I'm gonna need all the statements from account A and from account B for the full 5-year look-back history. Now, as far as deposits are concerned, they're also gonna ask you for copies of deposited checks if something looks interesting to them, meaning they have the right to ask you to give them a copy of every single deposit that you've deposited into your bank account for the last 5 years. Now, sometimes you don't have records for that. So what are you going to do? You're going to have to go to the bank and you're going to have to request the statements, and not only the statements, but you're going to have to request not only the deposit slip, but a copy of the check that was deposited. And very frequently, what I find in my practice is that people have deposits into their accounts, which when we get the copies of the deposited checks, it leads us to find out about other accounts that they've had that either they forgot about or they were open for a very short amount of time and they just kind of thought it didn't really matter. And this happens frequently. What happens is the monies were, one account, let's say, was closed and transferred into another account, deposited into another account. When we get the copy of that check, we find that there was another account, and now we have to go requesting history on that account. So basically, one leads to the next, which is why Medicaid is looking for deposits. Now, Medicaid is looking for withdrawals, and they're looking for checks. They want to see, what did you do with your money? Now, what they're looking for is gifts. They want to see if any monies or assets were transferred out of your name within the last 5 years into somebody else's name, or was the money used for somebody else's benefit? Now, monies transferred between spouses is allowed. Monies transferred to a disabled child is allowed. Monies transferred to basically everybody else is not allowed. So what Medicaid is going to look for is they're going to look for checks written out to other people. They're going to look for bar mitzvah presents and wedding presents and baby gifts and all kinds of things that we will do on a regular basis, and they're going to look for that. Now, if it's infrequently or it's small amounts, they're not going to penalize you for it. But when they see, you know, a lot of people have very, very many grandchildren. When they see that with each grandchild, the grandchild got a gift for a baby present, then a bar mitzvah, then a wedding, you know, it adds up. And then what happens is when they see that the money's adding up and adding up and adding up, and here we have $20,000 or $30,000 or more worth of gifts, that's when Medicaid is going to look at those gifts and say, wait 1 second here. This person knew that they were aging. It wasn't really a surprise that they were aging. They knew that there could come a time where they're going to need Medicaid to cover their health care costs. If they gave away all their money, why should we cover them? And that's basically their attitude. And especially here in Ocean County. Basically what happens is Medicaid looks for all those kind of gifts. Now what they also look for, and this I can't reiterate enough to anybody, is cash is a big no-no. ATM withdrawals, cash withdrawals, checks made out to cash, all of these kind of transactions, basically what happens is a lot of times people are using cash for their own living expenses. It's really, really legitimate. But we have no way of proving it. We have no way of proving to Medicaid and verifying to Medicaid that this money was really spent on the individual, on the applicant. We have no way of proving that the person didn't actually give away their money, they used it for their own benefit. And obviously that's a hurdle that we have to get over time and time again. But basically, if you could avoid using cash, or if you could keep receipts or keep documentation of all purchases or items that you use for cash payments, then you're going to save yourselves a lot of aggravation and a lot of possible penalty periods. Now, I'm just going to explain to you what happens when somebody gifts money and what is a penalty period. Basically, in a nutshell, I see the time is running out, so basically in a nutshell, I want to just explain to you that if somebody gifts away money, somebody gives away their money, or if somebody has transfers for below fair market value that they can't verify, Medicaid is going to penalize them. By penalizing them, I mean that they are going to say that from the time that this person needs Medicaid and from the time that they're otherwise eligible, they come and apply for Medicaid, and Medicaid says, now you need Medicaid, now you're under your $2,000 resource, and now is when you applied for Medicaid, now is when we're going to begin the penalty. And the penalty means a period of time of ineligibility. That means if I spent down all my assets by September 30th, And I'm thinking, okay, we're going to assisted living. I'm going to be in the assisted living. October 1st, I'm going to need Medicaid to start kicking in, and I need them to start paying. So I go and I apply for Medicaid, and I provide them all my documents, and I provide everything, and Medicaid comes back to me with a list this long, and they tell me, you have $35,000 worth of transfers that we have no verification for. And I said, what do you mean? I used it for my own care. They said, you need to provide proof for that. So unless you could really provide verification, Medicaid says, okay, you needed Medicaid October 1st. Well, as of October 1st, we're not going to cover you. We're going to implement the penalty period to begin from October 1st and last a certain period of time depending on the amount of the gift. So basically, the person now is stuck because he has no more money left. He's under $2,000 resource limit as of September 30th. And as of October 1st, he needs to pay privately to the assisted living or to the home health care or to the nursing home or wherever it is that he needs to pay. And he has no funds left. He has no money. So that's where the people get into a bind and issues and aggravation and a lot of heartache. So I want to, if I can impress upon you all, to please be careful with A, your documentation. Don't throw your papers out. B is try not to use cash if at all possible. And if you do, keep receipts, keep records of what you're spending your money on. And basically, I can say that by you keeping receipts and verifications of what you spent your money on, it means it's going to be a snap and you'll be on Medicaid because the Medicaid process is complicated. And I guess there's a reason I do what I do for the last 15 years. But the process is complicated, but it will make your process much smoother and much quicker. It will happen faster, it will happen easier, and it will eliminate possible penalties. So I'd love to answer questions if anybody has after we're finished. We're going to have a question answer afterwards. I want to thank you all for listening, and of course I'll be happy to hear all of your questions later. Thank you very much.
Thank you. That was definitely a wealth of information. And I know the hour is getting late. We have one more speaker, then we'll have some Q&A, and then there is dessert, so everyone can have some coffee if they'd like. The next speaker is Shimshin Samloey. He's a lifetime member of CLTC, the Certified in Long-Term Care designation, and he successfully is helping clients and financial professionals with long-term care insurance and retirement planning. So, thank you, Sam.
Mr. Mino, Mr. Weiss, for inviting me, and sponsors, like Courtyard. And all of you that came here tonight. I know it's late and I'm the last speaker, so I'm not going to keep you for long. I'm just going to try to cover a few important things about the topic is understanding long-term care insurance. Before I get into the product and how the product works and some important points to know when you go out and look for long-term care insurance, I want to talk about the consequences of not having a plan of extended care will have, not on you, but those you love. I'm just going to share a quick letter that I saw from an attorney that actually went through giving care for her father. So she writes, "My tears have finally arrived. I feel like my dad is being locked away and I'm powerless to do anything about it. I guess I must be in denial, but I can't imagine him living in a nursing home. It's heart-wrenching. I was leaving the nursing home, he came out from his room and followed me to the elevator. He asked if he could go home with me. I had to lie and tell him he could after a while, but not now. I'm just so sad I don't know what to do. I just can't live with the decisions I have made. Whatever I do is wrong." And then she's repeating, "Whatever I do is wrong. If I keep my father home one more minute, I may end up needing care. But if I place my dad in a nursing home, I won't be able to live with the guilt." So I just want to focus on that, on the consequences of not the people receiving care, but the people that become a burden because of it. I was thinking, when we all start raising a family, and our goal is to have good, healthy children, see nachas from them, and provide them financial support as well. And that's the ultimate goal for most parents. And as they grow and they get married, and they have children, we want to continue that. But what happens sometimes is all the work that we've put in all those years could start falling apart if we don't have a plan in place. If we don't talk to attorneys about putting together a will and proper planning. Because long-term care doesn't bring the family together. It tears them apart. And I'm sure attorneys and people involved can tell you many, many stories, and I'm sure some of you have that as well, where it tears families apart. So the importance of having the right plan and the right product and know what you have is extremely important. And for the sake of time, I'm just going to go through some bullet points that might be important to look at when you look at long-term care insurance. One I think is very, very important, especially in the community, is to know where are you planning to retire. Some people want to retire in Israel. Most long-term care insurance products won't pay any benefits in Israel. A lot of people don't think when they buy it, what am I buying it for? If their real goal is to retire in Israel, they have a house in Israel, they have to find, and there are some products that do, but you have to make sure you know what you're buying. You're buying a plan that will pay for it. The good thing about long-term care, it is portable long-term care insurance. You could really have it in any state in the United States, but as far as worldwide, there is only a few companies that offer coverage outside of the US. The other thing is, it's important to know if you have, what kind of benefit period you have, how many years. Some people don't know about that. How many years will the benefit last? Is it 5 years? Is it 10 years? Maybe lifetime. They don't sell any more lifetime benefits, but it used to be an option. The other thing to learn about, and it's probably a good idea to look on it before you go on claim, is what type of elimination period do you have? Elimination period means there's a certain amount of days that the insurance company won't start paying for care until you satisfy that elimination period. The older policies, some of them are 180 days, 90 days. And when we say the word days, it's not days what we mean, it's what the insurance company means. There's calendar days, there's service days. You want to know what that means. Service days means that they require you every day to have a qualified care in order to satisfy that day. So let's say if you have a qualified nurse coming twice a week to do home care, only 2 days of that week counts towards those 90 service days. I personally had a family member not too long ago that had a policy for many years, and in their mind they thought they had long-term care. Went on claim for a year and a half. They never got a dime out of the policy until they passed away. They didn't count hospital stays as part of the 90 days. And it's very hard to explain, but when you go through a catastrophic event like long-term care, it's hard for the family to be busy with proving receipts and calling the insurance companies and fighting for the money. And they do a good job in making sure that they only pay if they have to. So, and then a big concern right now for long-term care insurance is that a lot of insurance companies are raising rates for existing policyholders. There are still some companies that sell what's called limited pay products, which means that after a certain amount of years, it's guaranteed to be paid up. You don't have to worry about them raising rates. After that amount of years, they can't come back and charge you anything. So that's an option for people who could afford that. The other popular option that's coming out right now more and more is life insurance companies that have within the life insurance policy a long-term care rider. That's a very good option for people who do need life insurance to add that, because that you could use the portions of the death benefit towards long-term care. Also, you have to be very, very careful what the language of the policy is, how much of it will be able to be used. Some companies limit the amount, some companies will only allow you to use it for reimbursement, so you have to submit receipts. Other ones will give you a check and you can do with it what you want. But again, I know it's late and I don't want to overwhelm you with a lot of detail. I'm here to answer any questions. If you have any questions on your existing policies or you want to talk about any new policies.
Thank you to all of our presenters. I think everyone has definitely will be walking out of here with what I was hoping. When we started the evening, I said everyone will walk out with some information that they did not know beforehand, and everyone will definitely know who to call, who to speak to if they have additional questions. We will have time for question and answer, but I will ask you, what is your name now?
I have a question.
Okay.
And a suggestion. And the suggestion is, like, I was the one when we had to go once a year down and they're sick and they can do it, that we get the papers once a year. So I am proud that I helped a lot of people not to travel. Thank you so much.
And you know what Bill is going to...
Instead, the money should remain in Germany. You gentlemen should create a law. The money Israel should be the ocean from those people which got left there. Am I right or wrong?
Very good point. Bill, you have...
Questions? I'm sure you guys have questions. It's been a long evening, and thank you for your patience and the excellent presentations. Well, this lady, I'm going to start with you. You had your hand up 14 different times. You have a lot on your mind. And one of the questions, obviously, is if there's nobody to give the money to, I think, here in the U.S., you're saying it should or should not stay in Germany. I couldn't quite...
No, the money...
The money should go to Israel?
Money,
should go to the state, it should go to Israel, just to the state.
The money
Okay.
which the survivors get nifter,
Yeah.
and they have no offspring.
No offspring,
So the
no
money
surviving spouse.
which the usually goes to the children shouldn't remain in Germany.
Okay,
Should go
okay,
to
I got
Israel.
it. Okay. Let me answer the question. Guess what? Impossible, and here's why. What did I say before? The German government, okay, and this is what makes me crazy. I was standing in the back, and people came up to me, and they said, we work with this macher in Brooklyn, or this macher in Florida, or this person at Bicorcola, or this or this or this. And you know what happens? The money that should go to you, or to the siblings, or to the spouse, or to the children, stays in Germany, because if you can't figure out a way legally, and the system allows it, but if you can't figure out a way to take that money from the German treasury and put it into a survivor's pocketbook or family, it stays there. There is no, hang on, there is no law in Germany, okay, that says unclaimed Holocaust monies as a charitable gesture should go to the state of Israel. Now, Germany does make donations and contributions to, in the back. They do make contributions to certain charities. This organization called the Claims Conference, which is very involved. They have money they give to foundations in remembrance. But I will say this. If people aren't smart about how German compensation works, whatever money you can't figure out a way to collect, it stays there. And it's like you're making a donation to the government of Germany. It's outrageous, but that's what happens all the time.
Well, you German gentlemen, you laws should fight about it.
Every
Should do
day,
something, but
ma'am.
you don't give up.
Ma'am?
I mean, we have to fight about
We're
it.
going to move on. Is there anyone else who has...
Question. Go ahead, you.
We should put them on a guilt trip.
That's a good idea.
Am I right? To put them on a guilt trip.
Advocate for a law that it should go to Israel, not that it should just go to Israel. You guys should be advocating what.
Yeah, let me just tell,
It's a very good point, not the purpose of this meeting.
guys, can I just say, it's a great point you make. You make a phenomenal point. But I am here to tell you what the reality is of German compensation, not what we would love to see. Let me tell you, the ghetto pension law that just passed, and this is to your question too.
That's not my question.
But to the point that you clarified, how about that? You clarified her point. And the point that you clarified was that we should do everything we can to wage a campaign to get Germany to do the right thing. Germany, on June 5th of this year, they passed a law with respect to the ghetto pension, that all new ghetto pensions should now go back to 1997. Here's something interesting. The law that said that was passed in 2002. It took Germany 12 years to do the right thing. So when you talk, and that was after legal challenges and political challenges and multiple guilt trips like you can't even imagine, to get them to do the right thing, it took 12 years for them to do today what they should have done in 2002.
One last question.
Does $400 a month for a couple in cash seem unreasonable? Is that something that the Medicaid people would question?
If it's consistent, he's asking if $400 in cash, if you withdraw $400 in cash every month, is that a reasonable amount of money to be able to withdraw?
Yeah, we need for
If it's consistent, if you're using it on a regular basis all the time, and it looks in your account as if you could be using that money, then it will be okay. The reason I'm saying that is because if they don't see, let's say, grocery shopping and all your basic necessities coming out of your bank other than the cash, then they're going to say, okay, well, grant that $400 was used for necessities, so that's fine.
Okay, I think, okay, there's one more question in the back.
Honestly, it's better, if people have questions, I'm prepared to, it's better to do in this context. Otherwise, I've done this number. Let people ask something, if people can stay, let people ask something.
In the back there?
I understand that the New Jersey inheritance is anything above $675,000 now, whereas New York is you're allowed over $5 million. Is there any chance that New Jersey is going to raise it?
I'll just repeat the question. The question was that we mentioned that New Jersey has the state tax exemption of only $675,000. The federal exemption right now is at $5.34 million. Many people think that New York's exemption is actually, as of April 1st, equal to the federal exemption, but that's actually not. That's a misnomer that needs to be corrected. That New York by 2017, 18, 19, we're slowly going to increase to meet the federal level. In New York right now, it's actually near $2.1 million. As far as the state of New Jersey, as far as them raising the exemption level, I have not heard of anything that's going to pass anytime soon. So that's really the answer to that. Yes.
Rising mentioned about $10,000.
Sorry?
Rising mentioned something about $10,000 for Holocaust survivors, German money.
$10,000 for Holocaust survivors from German money. They will make a one-time payment because they really, really, really care about younger survivors, and I put that in quotation marks. If you're born after January 1st, 1928, once legislation is passed in Germany, which it has not yet been done, all survivors born after January 1st, 1928, who also meet certain other criteria, will get 2,500 euros. A one-time lump sum payment. Under the current exchange rate, that's $3,100. Everybody who is alive today, this is not on behalf of second generation, but somebody who is alive can make that application, and eventually, probably sometime in 2015, will get the payment at roughly $3,100.
I mean, we have to keep
Nothing,
Her 10,000 was referring to the ghetto.
put them in a big youth that they
Nothing.
to put them on a bigger Q-tip than they are.
Okay. Nothing is available yet in terms of
Poland.
applications. But again, there are, and this is relevant because there are three main kinds of pensions that Germany pays to survivors. One is the Wiedergutmachung pension. Since the 50s, that pension is exempt, as Mindy and I are talking about, for Medicaid, and it's relevant. The second pension is Article 2. It's every 3 months if you don't get Wiedergutmachung. And the third pension, whether you get Wiedergutmachung or Article 2 or neither, is the ghetto pension. Those are the three main ways that Germany pays survivors. And then there are these one-off lump sum programs, most of which have now passed the deadlines, but now there's this new possibility of the 2,500 euros. And that's the universe of Holocaust compensation today.
Okay, so with that, I know there's a woman in the back over there who's been waiting very patiently, yes. This will be the last question, and then we will...
First of all, this is not Councilman's question. Is this going to be available as one of your?
You can talk to us afterwards, we can do that for you, yes.
I wanted to ask about the halachic wills. If there is a person who has 3 daughters, so how does that work in terms of?
Any sons?
No sons.
So it would be split equally between the 3 daughters.
Split equally between the 3 daughters. That's not a problem at all.
We're talking about if one doesn't write a will, if one writes a will, whatever, you know, a halachic will.
One writes a will, that
Right,
it
but
goes.
without any will, it would automatically go to the 3 daughters.
Right, and.
So you're talking about a man or a woman?
So, both. In other words, like,
Different. If it's
first it'll go to the spouse.
not necessarily. It's in other words, the
husband would
if the husband wouldn't pass away, it would go to the daughters.
I'm sorry?
If the husband would pass away, so the wife would be entitled to kesuba and residence and food and sustenance, but the actual estate would go to the daughters, not.
How would it work?
Unless you write a will, a halachic will, then one could give it to the spouse. But just the way the Torah set it up, it would not go to the wife. It would go to the daughters.
Okay, once again, thank you very much to everyone for participating, and have a good evening.